Well, good afternoon, everyone, and welcome to our session on a new era of data protection in India and CryptoBind's blueprint for DPDP Act Compliance. So, today's webinar will dive deep into DPDP Act, what has changed, what compliance truly demands right now, and how organizations can build a scalable, future proof data protection strategy. And for that, I am delighted to introduce our speakers today. Our host, Ms. Isha, CEO at JISA Softech, a strong advocate for data protection, security innovation, and privacy solutions. And also joining us is our panelist, Mr. Ashish Dhar, Senior Advisor for Data Security and Privacy, with years of experience guiding organizations through regulatory compliance and real world compliance challenges. And with that, I thank each one of you for being here. This session is going to be very interesting. There are a lot of new things that we all are going to learn from Ashish sir, and I'm very excited to get to know more about the recent news and all the buzz around that we all have been seeing on LinkedIn, what it really means and what's in it for all of us. So over to you, Ashish and Isha.
Thank you, Nelson. Good afternoon, everyone, and welcome to the episode 4 of our DPDP webinar series. And it's incredible to see the community growing with every session. Today's topic is important, it's practical, and it's time sensitive because we are entering into a stage where compliance is no longer going to be theoretical. Enterprises must prepare for implementation. So, before we begin, I just want to set the expectations of today's agenda. Due to time constraint, we will not be able to discuss on all the four C's of DPDP rules like consent and notice, child consent, cross-border transfers, and contracts because DPB is expected to release furthermore clarity on these areas. So we'll cover them maybe in dedicated sessions later on. Today, let's focus on about 7 to 8 questions, which are specifically around rule number 6, 7, and 8. Since enterprises, especially BFSI, and other regulated sectors are asking for it right now, so let's begin with that. To get clarity on the draft and the final rules, Ashish, I would like to ask you or help us with a quick summary of what has changed between the draft, which happened in Jan 2025, and the final rules, which have come out on 13th November 2025.
Yeah. Thanks, Isha, and thanks, Nelson, for the introduction. Really excited to be all with you. We are, entering a great era where the digital economy is going to grow leaps and bounds, and with that comes a lot of responsibility. And this DPDP rules has reminded us that every one of us, including citizens, the business, the enterprises, have a lot of responsibility to understand that privacy has become a fundamental right. So maybe if you can quickly move to the next slide, that will help us understand how was the journey so far. And if you understand, we all know about GDPR, but if you see this slide, you see that our journey started beyond earlier to GDPR. And in the IT Act of 2000, there was SPDI, the Sensitive Personal Data Information rules under IT 43A section of 2000 bill, which talks about what kind of sensitive or personal data we should be handling, managing, and taking care of that. But since the rules came quite ahead of its time and India's digital journey was not that mature, businesses didn't really consider to that importance. But then when the digital privacy got established as a fundamental right, I think that's where the real focus came back to considering data privacy as one of the pillars of any economy. And from then, we know, we have been all excited, and me and Isha, you were part of some sessions together. We did our DPO certifications, and we were eagerly waiting for the last 1.5 years. And finally, the D-Day came when, after the January 2025 notification of the rules for draft consultation, finally, just on the eve of Children's Day on 13th November, we saw the gazetted rules getting published. And that's where I think we stand now and we are all trying to understand. So let's move to the next slide where we will understand based on the rules that got notified on 30th November, what exactly are the provisions in that rule and how we are going to handle the different provisions of that. So basically what you understand is there are about 23, 24 odd rule sets, but from T0, which is the date that got notified the rules, I think the most important rules that got notified is about how government is going to set up the data privacy board, the different office bearers, how we should work as a organization, as a regulatory entity, and it should work more as digital office. So most of the rules are concerning around establishing the regulatory board, and then we understand going forward within the 1 year mark, exactly on 30th November 2026. By that time, it can be earlier to that as well. The consent framework, which is one of the bedrock of this data privacy, would have to be established. So government has listened all these years through different consultations from different regulatory bodies, businesses, different kind of tech organizations, be it big tech, be it social media, and they have taken care of all those concerns and risk highlighted in the different parts of those rules and align that with the act. So we need to be also very careful that whenever we are interpreting these rules, we also have the act interpretation of the different guidelines, the definitions side by side, so that the things are getting absolutely clear. So what we need to understand is after that 1 year mark, when the consent framework is established, the actual implementation and full compliance would start 6 months later. So within 18 months, we should see the complete data privacy landscape getting a kind of compliant with these rules that we are talking about. So one of the main aspects of that is obviously when government brought this rule, one of the main consideration was that we have been seeing a lot of cyber attacks, data breaches. So it is not only data privacy we are talking about, because security and privacy should go hand in hand. So whenever we are implementing the full set of the rules, we really have to understand that with privacy there is a security which is the bedrock, which should help establishing the rules, the capabilities, the obligations that we need to protect. So we will talk about those points hopefully in details in this section going forward. Isha, over to you.
Okay, thank you. I think even though it was quick, but you've very clearly been able to, differentiate and tell us what's new and how is the timeline which enterprises have to meet. So there's a lot that we have to know more from this. So moving forward, I would say, JISA, it's being a security product company with a key implementation requirements with our BFSI client base, which is more related to rule number 6, which is like
Correct,
security safeguards and controls.
correct,
So what is understood by the term reasonably safeguard when we read rule number 6? So what do we understand by reasonably safeguards, and what type of controls should be implemented by our clients, which are, as I said, more of BFSI and other clients?
correct. So if we move to the next slide, that's a very great question, Aisha, because we need to understand that the most of the security safeguards and the associated kind of rules that will govern how we are going to retain personal data, collect personal data, process it, right? All those
Yeah.
aspects are actually being covered in the three rules, which are one of the main points and main areas that companies and organizations have to implement, right? From a technical implementation, business process point of view, and operations point of view. So, Rule 6 talks about the security safeguard, which one needs to understand that when we are handling personal data, organizations now have to fundamentally rethink the way they are looking and managing and processing data, because they cannot now collect data on an ad hoc basis because there are certain privacy principles that we are going to talk about. So maybe if you move to the next slide quickly, we will need to understand that in this privacy principles that we have in the next slide. Yeah, so we will have to understand that the rule, and more than the rule, the act talks about that whenever we are collecting data, we have to take consent, we have to give enough notice of why the purpose of the data getting collected. So there has to be a privacy principle of purpose limitation. We should not collect more than what is required to fulfill the service to the data principal or the user or the customer, the organization or the business is servicing. And more than that, along with that, I mean, whenever we are collecting those personal data, we also need to understand that while doing it, we have to secure the data from the point of collection to the point it is moving to other partner ecosystems, other vendors, other contractors, because in our IT and business landscape, we have a very rich ecosystem and our digital solutions are all integrated, right? So at each point of the time, the data is moving across this IT and the business landscape. We must ensure that while data is at rest, when it is being stored, when it is being transited, or when it is being used and processed, the privacy enhancing techniques like encryption, masking, obfuscation, anonymization, and all these concepts that I think JISA is a pioneer in the market already that we know from its CryptoBind platform. So all this becomes a key implementation parameter to safeguard the personal data of the data principals and also kind of maintain compliance because we cannot retain customers' personal data for a lifelong purpose because there is a storage limitation that the government is talking about in the subsequent rules. So, in a sense, we have to now think of re-architecting our IT and business processes to ensure that the security safeguards, the reasonable term to a lot of people might sound vague, but again, this is a very standard term used in most legal and legislations around the world, and it gives you a baseline, and the rules have talked about some of those baseline criteria. You can, as well as based on the sensitivity and the volume of the data, and also based on, I think there is another discussion topic which we need to understand is now with the AI coming into it, we are processing data in different ways, right? And
Yeah,
most of the time we have to secure that from algorithmic use. So in a way, we really have to take care of the rule number 6, which specifically talks about implementing the privacy enhancing techniques. So if you can quickly move to the next slide, I can talk about a few more aspects of that, which Isha, you already know, right? I mean, this is
yeah,
something that is going to impact us in a business, and you must be
absolutely.
hearing this from your clients. So if you can talk about that a little bit.
Sure. I think you as you rightly mentioned, yes, we I can relate very well when you talk about privacy enhancing technologies. Since we do this day in, day out, so definitely I see the alignment when you talk about this rule number 6 and how our clients can actually help safeguard their data. And I think this is one of the change or update which Act has also come up with being more clear about what needs to be done, even if it's used with those, with a term of reasonable safeguards. But
Correct.
definitely there is something which is bare minimum and there's no
Correct.
compromise to it. So this definitely helps. So considering this, burgeoning challenges of data management and security due to its volume, velocity, and the volatility. Since we talked about, BFSI, obviously there are the data is huge. So looking at that, the things now get more complicated for organizations, and organization would not only have to identify the personal data, but they have to secure it, manage it, as well as make sure that they comply to data retention and deletion requirements, right?
Absolutely.
So what kind of automation solution would help in here for organization to ensure meeting compliances with data deletion, retention, as well as all other steps which they need to take care of?
Absolutely. I think that's a very, very essential part of it because if we go through the slide, if you just move across the slide, it touches on the points about the visibility, volume, and velocity. So can you just quickly run through this slide? So this is basically that we have to understand that in our business landscape, whether we are on-prem or on the cloud, we can only manage the data that is visible to us, and most of other data, which is maybe a year old, becomes kind of out of our radar. So there is a lot of historical and legacy data, and the rule talks about that in a way which I will cover in the next steps. But what is more important is at any point of time, we now have to look data across multiple timelines, right, while it is getting collected. So there's a retrospective effect which we have to handle in compliance with this. And then there is a lot of digital transformation happening around us. There is a lot of data sprawl because of which we see a lot of challenges with respect to data surface attacks, people getting the different kind of frauds and scams, ransomware attack, identity thefts. So these are obviously the challenges which now with this act coming into place, these rules coming into place, gives us a way to mitigate all of that. So if you can just quickly move to the slide, I will start talking about the different parts of how a data lifecycle should work about, right? I mean, if you understand, and the rule talks about all of them, right? It talks about when you are collecting data, you should go through certain guidelines, right? I mean, the consent, the privacy notice is talking about that you should only collect that part of personal data that is essential and that you have to take a complete itemized kind of a notice, and then you start collecting that. But the real challenge for enterprises is that the rule says that you not only have to inform your new customers who are now going to come to you, but all the customers you already have onboarded, your
Yes.
existing customer base. You need to understand their personal data, their sensitive data. When did they got onboarded? Are they still using it? Are they still a customer or a consumer to your business? Right? If you don't, and once you do that analysis, then you have to seek a fresh consent from them and give them a bouquet of what personal data that you should need, because even maybe 5 years back you have implemented some solution, and now 5 years down the line the systems have changed. You have got an IT landscape or business landscape expanded. So you have to tell your existing users that, okay, I have collected your data 5 years back, and these are the data that you have provided me. Do you give me the permission to keep continuing this data? And if not, the customers can as well withdraw their consent, saying, okay, I don't want to be allowing you use of my personal data. So these are some of the challenges. So organizations have to implement some automation solutions because to take care of all the legacy effect, to take care of how my data is getting stored across my complex business landscape, IT landscape, across multiple my processing partners, my data processing partners, right? I have to make sure that my data is going through this particular life cycle, and we call it a cradle to grave solution. The point data is collected is your birth of the data till the point your customer is leaving. You have to ensure that his or her data is properly updated, is properly protected, and you are retaining the data even after 1 year of the customer leaving you or disassociating from you. And when you even do clean that data after a year of inactivity, you still have to notify that particular customer, which means you still have to have the contact details or some channels with which you can approach the customer, telephone number or email ID. So this becomes a very critical and complex operational process for organization to understand. So maybe we quickly move to the next slide to understand how this data lifecycle management would be implemented and what kind of sensitive data their assets and formats we have to take care.
Mm.
And as I reminded you, though in this particular act and the rule, it doesn't talk about the specific kind of personal data, whether it is PII or PCI or PHI. If you understand, PII is a personal identifier information. PCI is related to our financial information related to cards and associated banking industry related sensitive information, and PHI is my healthcare information. The SPDI rules way back in 2011 did already talk about all this thing at that point of time. So we already have now a baseline to start with, but then as I said, in the age of AI, I think we have to be more careful because the rule talks about even when there is algorithmic use of personal data, it should not be abused or used in a way that a personal kind of harm is being harmed to the individuals, right? So we need to understand the organization needs to implement a automation solution where it can do a full discovery and classification of all this sensitive data that you see on the left side. And on the right side are the different formats, the structures, semi-structured, unstructured, and even the AI vector DBs where your data is flowing into, right? So you need to have a very clear view of this while you handle data processing of personal data as to be compliant. So maybe next slide, please. Yeah, and this is the three main categories of our personal and sensitive data, where DPDP will directly be coming, and you have to be complying with that. I just mentioned about the PII, PCI, and PHI data. Uh, right now, there are a certain very specific and sensitive PII. So SPDI even talks about your sexual orientation, your religion. So we need to see whether this SPI is also going to be covered, and we have to wait for the DPP notification. But in other Western countries, there is also a very strict regulation around usage of sensitive PII with respect to race, ethnicity, religion, beliefs, and sexual orientation. But to be sure, PII, PCI, and PHI are something that the rule and the act mandates us to protect. And that's the reason this technical solution that we will give a glimpse about will help us understand and it much better. Isha, I hope that answers the question.
Yeah, quite detailed. In fact, while you talked about it, there were a couple of things coming to my mind, and I think, of course, the question will follow. We have something about, old past customers which are onboarded. So there are some, questions around that definitely coming up next to you. But since you just talked about data discovery and classification, this curiosity that I also had, and I'm sure our audience wants to have a little more detail about how data discovery and classification will help organizations to comply with the DPDP Act.
Yeah, I think that's a very, well framed question, Isha. I think that's something which is going to help simplify and also help comply with the different sections of the rules. So maybe if you go to the next slide, I will give you a quick view of how the different data lifecycle management processes that we talked about in the previous slide, how we can put a process, an automation process altogether. So as we speak, we know that, and from a retrospective point of view, the legacy data that we have. So it is humanly impossible for any organization to manually keep track. So I used to work in the 90s, late 90s on ITIL, which talked about configuration management database, right? Now, with the proliferation of the digital stack and AI and all other automations, right? Uh, it is very getting very outdated, very fast, right? So we really need to have a solution which is working round the clock, 24 cross 7, 365, every time, real time basis. So you need to have a system in place where it can discover, go into your IT landscape, whether it is on the cloud, whether it is in the data lakes, whether it is in your on-prem, whether it is in your personal data stores like you have got, right, your Google Drive and any other spaces, and help you do automated discovery of all types of personal data. So you have to define certain rules, which we call classifiers, which will help you detect this kind of personal data, the PCI, PII, PHI types I talked about, right? And then you also need to understand whether you are managing those data with the right security principles, because we know that at any point of time whenever a breach happens, and most of the time the root cause tells us that it is possibly a bad security configuration, whether if the data stored where it is supposed to secure, your personal data is not well secured with access controls, with good password policies, with good secrets and APIs hardened around that. There is all the chance to have that data getting exfiltrated or data getting breached. So you not only have to discover the personal data, but also understand the risk, associated security risk of those data stores, and flag those
Right.
misconfigurations. And then you go ahead and I think this is the area I think JISA is already working very deeply with your BFSI clients, where you go secure and limit access, right? Where you
Yes.
protect data assets through different kind of encryption techniques using the different Aadhaar vaults and PII data vaults and the HSM modules that you have built in. So this, the third phase, the secure and limit. So the first two and the third, first to the third phases, these three phases should work as much as automated way as possible with minimal human intervention, where the system will give you enough real-time information. Where human intervention come is when you have to remediate those risks and then start governing your personal data processing life cycle, and ensure that the auditors and the compliance guys and the legal guys, when they come and check your system, they have something which they can be happy with, because most of the time we will struggle otherwise to manually generate this kind of a reports. So in a way, this is a very key for all of us to implement and understand. Over to you, Disha.
Yeah, absolutely. I mean, you've covered probably a little beyond the data discovery and classification. So I'm sure those who are willing to understand more about it, they also understood that what next could happen once you identify the data and what are the important steps one has to take care of. Though I'm sure I'm going to come back to you and ask you a little more on that as well. And
Sure.
while you just mentioned something about need of the automation, it's just not because of how fast we are moving, how data is moving, but I think another need is because of the penalties. So definitely one
Absolutely.
cannot afford to have a lag while implementing any system where there could be even a point 0.0001% chance to have that breach happen, because it's going to be a big thing. So definitely this gives a clarity. And while talking about it, I think the next question which I have around the Act is that the Act has in place that organizations, which the point which you mentioned sometime back, that organizations would have to provide notice and seek consent for
Absolutely.
processing PII data even for the past onboarded customers. Okay,
Correct.
so how organizations can identify such users and then comply to the requirement?
Yeah. So I think as you said, I mean, the compliance and the penalty is what got everyone at the same time excited and concerned about in the business ecosystem. So we can quickly move to the next slide, and I will try to explain that. So, I mean, we have already discussed all of this, and I think we can move to the next slide once more. Yeah, the next one as well. Yeah, so I think this is a topic which we'll discuss, but yeah, maybe the previous slide will help us understand. Just go back to the previous slide. So when we talk about the penalty part, can we move to the next previous slide, not to the next one? I think we just skipped. Yeah. So when this data privacy rule came in, I think the penalty got everyone get notice. So I think the motive is just not to be comply. I think the motive behind this very well drafted act and the rule is to bring transparency and trust in the ecosystem, whether it is the fundamental right of a citizen, and even if it is a government entity, even they are given certain boundaries and guidelines to comply with, right? So any person in our country, if they are being made aware that privacy is a fundamental right and any kind of data must not be misused, we need to obviously bring in some penal kind of a clause, so that if it is misused, then there is a way to make people pay for that, right? Now, obviously, in our act, we haven't got a way that individuals can go and ask for that penalty, but they
Yeah,
can obviously have a mechanism called Data Protection Board through the DPO. They will go. So if we have to understand this, to answer your question, is as I said, we have to use this data discovery bit of the solution to understand all the past customers that I have already got onboarded and what kind of relationship I still have. So you have to first go into your CRM system, and from there you have to trace through the data lineage part of it, right? So data lineage is one big aspect where you understand over the years how your customers have been using different services, products, and different channels, right? Because the life history of the usage of the service would be visible to you in a graphical mode through the data lineage. That's one part of it. You also need to do a DPIA assessment to understand where do you stand with respect to the rules and regulations, and how big is the gap, right? Because if you have not got enough safeguards, enough controls in the past, then you will need to do stock checking with respect to where do you stand today to comply with the rules 6, 7, 8, and do a gap analysis. So DPIA will help you with that to comply with the different provisions of the rules. So in a way, this will need to do through proper implementation of technical controls, organization controls, and regulatory controls. So this way, we will be able to build a step-by-step roadmap which can help organizations to take through the journey of privacy. Yeah, Isha.
interesting. I'm sure this would have helped a lot of people to understand, which would have been the bigger question for them, that how do I deal with my old customers or old data? And I think so, which means data discovery and classification is a very powerful tool where you identify
Absolutely.
what's there in the past, and then obviously apply all other solutions or measurements and everything. But then this will help, and DPI is another way which you mentioned.
Yeah, absolutely.
So absolutely, when we talk about this, I think this, when it gives confidence to the audience and enterprises in terms of dealing with the old customer data, I'm sure still there is a data breach notification, which is a very big
Yeah,
ask by the act. So you need to be on your toes. One is, of course, nobody wants to make it happen, but if there is a data breach, then is database notification going to be a challenging proposition, from the incident reporting and the management perspective. So, in case of such thing, what should be the approach? Because there are a lot of other regulations as well, which talks probably something different. So,
Correct.
how should be the approach about it?
Yeah, so again, this is something which is really going to be a complex thing. And I'm sure organizations like JISA and your clients have already started. And I know business from banking and insurance sector, I get emails which tells me that they are trying to ask me whether you still use this particular account because we don't see any activity in that account, right? I mean, we have been getting emails from
Yes,
some of our past banks that we have transacted but not active now.
yes,
So I know, I think this process has already started. The mature organizations have understood from the day when the bill was passed in 2023 that there would be a lot of thing to cover. And and the credit to the government is they have still given at least one full year to go through this implications of this. But the other thing is about the next slide, which comes when there is a crisis, right? And if you just click that slide, it will tell you the fun thing about what we are trying to highlight. If you just click the slide once more, it will tell you that privacy is a hot potato. Because whenever a data breach happens, you see passing the bug game starts, right? Everyone will start to point finger at other departments saying it possibly have happened through you or him or that. And between the data fiduciary or the significant data fiduciary, everyone would have a plethora of vendors, sub partners, ecosystems where they have to share the data and they become their data processors. But important thing is, even if your partners or your vendors are processing the data of your customers on your behalf, you own the obligations and responsibility for ensuring that the data breach doesn't happen in first place. So obviously, we go to the next slide. One is that we have to understand our partner ecosystem well. If you can move to the next slide, please. We understand that we have got this ability to react, respond, and remediate at a very fast pace because the rules tells us that whenever a breach happens, you have to notify the data protection board
yes,
at the earliest, and unless you have got a system in place which will tell you from which data store or which application or from what kind of data has gone out, because normally a breach notification happens when you get something in the dark wave or some ransomware attack claims that okay, they have got certain hold of data, and they will give you a sample of the data to give you a proof that that's coming from your system. Now, when you are giving the data, you just looking at it, you should be using the data discovery, classification, and data lineage should be quickly able to pinpoint which part of the ecosystem of your digital landscape that data has been got stolen. Is it from your system, from the cloud, on-premise, from your employee mobile or laptop, or your partner or a contractor? So the first thing is to use the technology that I mentioned in the previous slides to pinpoint that source and then understand that the rule tells you to also send a notice to the data protection board, and also within 72 hours of notifying the data protection board you also have to notify your customers, the data principals, and tell them what data has got leaked out, how they are impacted, what kind of security or remediation that they have to do so that the data gets protected. And I will give an example of how it happens in developed countries like Australia, UK, or US. I have brother living in Australia, and and the telecoms. I've worked 15 years in telecoms. I know telecoms service providers are one of the most hard-hitting kind of vendors when data breach comes in. So my brother got a notification from one of the service providers he was using in Australia that your driving license has been found to be in a data breach, and we will be helping you with get a new driving license. You go to this help desk number, you send your details, and we will ensure that we get your new driving license issued within the next 1 week. So that kind of transparency, trust, and maturity we have to bring from our organizations, so that as an individual customer citizen, I am getting the assurance that my there is no harm, or I'm not going to be impacted because of a misuse of this situation. So in a sense, we have to have a very good playbook, very good coordination, collaboration between all the stakeholders, internal to my system, external to my system, to the regulator as well, so that I can comply with the breach response timelines. And what is also important is, in the banking industry or the insurance industry or telecom industry, we use a word called know your customer, KYC.
Yes.
I think the Data Privacy Act is now telling you know your customer's data or know your data. And the third part is know the risk. So KYC, KYD, and KYR is how I kind of summarize what organization would have to do. Understand the customer, personal data, sensitive data, understand where, how that data is being processed, accessed, and what are the risks involved in doing all of that processing, and how do you safeguard that. So in a sense, the 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 rule helps us get our processes more mature, more honest, more transparent, and more responsive, so that we fulfill our obligations to the data principle.
Oh, okay. That's right. I think there's a lot, of course, for us also to do and reach a long way. And
Absolutely.
with this, clearly, I see a lot more emphasis on, understanding customers' personal data, understanding the breach response timelines. There has to be a clarity in what you're communicating, taking the accountability, because this all is needed. And I'm sure there's a lot more exploration even for new technical capabilities and automation for an organizations to ensure that they're able to manage this seamlessly and automatically. So this is definitely going to help organizations to explore more, think more, and be innovative about the
Absolutely.
solutions they are going to figure out. So while doing this, and when we want to have so much to be done, which are some of the priority actions you suggest in line with DPDP compliance that customer has to start from now? Not to wait for it, but they have to start from now.
Yeah, so I think some of those points that I talked about is we do the next slide, which will give a quick view of that. I don't know how much time we have, but I will be a little bit quick on this. But this is a journey, right? As you rightly said, Isha, things has to be taken, the low-hanging fruits first, and then as you understand the implications of the rules, you build more maturity. So it has to be matured in steps, but first of all, as I said, the first step is uh, uh, going beyond knowing your customer, knowing the customer data, how it is being processed, and more specifically, knowing the sensitive data, and ensure that you are classifying and tracking the sensitive data information while you are servicing your customer across its life cycle. Map the different data flows from within your departments to your contractors, partners, your third party providers, the regulators as well, and define and limit the purpose and means of how the data has to be shared and collected, implement security safeguards, implement data retention and storage mechanisms to comply with the rules, automate the rights and notifications about what data principals are going to ask about their data. So this is a very important thing which we can cover in next webinar, is about the data principal rights and obligations, where data principal can ask the data, his or her data, to be corrected, or deleted or updated, right? So
Mhm.
they will come with their requests to you, and you have to have some SLAs to fulfill those requests in a time-bound manner. So, and if there is a issue with that, the data principal can even approach your DPO and go for a grievance redressal mechanism. So I think there are a lot of safeguards that the organization have to do to comply with this, because at the end, also any channel that you are providing your service, whether through it office, through your web, through your WhatsApp, through your SMS, or any of the touch points, physical or digital, you have to keep showing to the person who is going to come and get a service by submitting his or her personal data, what kind of notices and consent that you should provide. You should do all of that. And last but not the least, though it is part of a legal thing, and we are not going to cover that in this seminar, we can talk about that later, is lot of renegotiation of the vendor contracts, because the data fiduciaries would need to ensure that their data processing partners, IT partners, managed services partners are uh, kind of also complying with that. So there has to be regular periodic audits, periodic security checks that has to be enforced, so that this compliance journey becomes a wholesale journey, not bits and pieces, but it gives you a full picture, hopefully, with
Yeah.
this.
So I think you've just covered absolutely what was going to be next question, or the question I had on my mind about the overall compliance journey. So anything more you want to add on to this, or or anything that you want to give message to the audience, talk a little more about this compliance journey, because I think, yes, we will not have much time, so maybe we can just give some message to the audience or the enterprises.
Yeah, so I think it's a journey which possibly has started for most already a few months or a year back when the draft rules came in. So if you can move to the quick slide quickly to the next one. This is a timeline slide which talks about, if even you have not started the journey, how you should approach this. And the first thing is obviously to establish a data privacy organization. And as I said, you refer to that hot potato. Data privacy is have to be a facilitator and make sure the security, legal, compliance, audit, operations, sales, marketing, all are aligned with a singular kind of an objective, which is to build trust, transparency, and security safeguards for our customers. So you have to do a data protection impact assessment. Then, based on the gap that you identify, based on the volume, velocity, and volatility, and the quantum of risk, you can think of evaluating certain technology solutions. We can talk about that maybe in future. What JISA is helping taking it to your business in your banking and finance. So you can use the data discovery, classification, tagging, and lineage solutions to help with build those security safeguards and mitigate those risks. And then you start evolving your privacy policies, security policies, and then as there is about a year and a half to implement, you can build those pieces of consent management, data principal right management, obligations of data fiduciaries, breach and incident reporting, and obviously do periodic privacy governance and audits. So in the next 6 to 12 months, you achieve that, and then maybe you have enough maturity that you can start doing this in a more periodic, automated, and in a proper governance structure. I think that way you should be able to mature your systems, processes, and also create enough awareness within your internal employee base through trainings and interventions, and also make your customers aware of their rights and obligations. Isha.
Yeah. Okay. I think in a way we see there's a lot of time, but I'm sure those who are implementing will definitely have a little panic situation maybe to start with, and once they get hold of it and they understand it, it will be a long or a smooth journey, even if it's long. But I think there's a lot which we would have to discuss or talk about. Like we said, there are certain points, 4 Cs, which are there. So we'll definitely would like to have you more with us on discussing about these aspects, and more as and when it gets mature. With time, we'll talk about it more, because I'm sure it will help our audience and the customers and everybody to know more about it. So keeping
Absolutely.
that in mind, I think we may have to probably, close this session for today. But and absolutely, it has been amazing to have you and have so much of discussion around. And especially when the act has recently come in, I'm sure everybody has a lot of questions. What was there earlier? What is it now? What's new? How are we going to meet up that? And this helps in getting a lot of clarity. So I think thank you, Ashish, for being there, for being with us on this webinar, as well as everyone who joined today. Uh, Thank you for being a part of this learning ecosystem. CryptoBind, which is by JISA Softech, will remain committed to share more knowledge, empower organizations with more clarity, capability, and confidence, so that you're able to achieve what you want to do that. And we don't end here, but I think we are also coming up with one in-person closed-door DPO event very soon, in the month of December mostly. So please follow our LinkedIn page, and you'll get to know more about it. And till then, just stay informed, stay secure. And thank you once again, everyone. Thank you so much. Thank you,
Thank
Ashish.
you, Isha. Thank you, Isha, for having me, and it's a pleasure talking about that. I just have one slide, which is a little bit humorous slide.
Absolutely.
If you can show it to your audience, they will love it.
Yeah, yeah.
If you can just move to the next slide. So this is a humorous slide I put in the day because I have been waiting, like you and a lot of other my practitioners, privacy practitioners, when this law will get enacted. And like Indian marriage, right? Arranged marriage specifically, there are a lot of discussions going on and
Mm,
on the day that event happens, I think we see different stakeholders in the ecosystem expressing different emotions. So this is a humorous take on how Data Privacy Act is enacted, solemnized, like an arranged marriage, and different players, be it business, startups, integrators, the DPO, the data principals, and concern manager auditors are excited, concerned, worried, but at the same time, they know this is all good for the future of our country. So I'm sure this will give a big boost to our economy and mature our systems. And I love to help you in this journey. So I think we will be reaching out. I think people have some questions, but maybe because of short of time, we could not cover that. So please do post those questions whenever
yes.
we send this out.
We
You
can
can have
actually have
those.
those questions answered later. And this is very well
Absolutely.
put up on each stakeholder, how what state they are into right now. That's interesting. I think okay, we will take up the questions on chat. Thank you so much. Great having you here, everybody. Thank you so much.
Thank you all. Bye bye.